Welcome to today's episode of the SADF podcast. I'm your host, Tapas Kanti Baul. Bangladesh is once again at a defining constitutional crossroads. The country is witnessing a deepening political rift surrounding the July National Charter, a reform document endorsed through a controversial referendum now fiercely contested in parliament and across party lines. Tensions have escalated sharply between the two major opposition blocs, the Bangladesh Nationalist Party and Jamaat Islami. Just days after the February 2026 parliamentary session convened, after the election, Parliament was thrown into crisis when BNP MPs refused to take the second oath associated with the July Charter and its Constitutional Reform Council opting only for the constitutional oath. Meanwhile, going against the constitutional norms, Jamaat Islami lawmakers took both oaths, aligning themselves with the reform framework and pressing for its full implementation. The disagreement has widened into a full blown political standoff. Jamaat and its allies have been threatened boycotts and protests over BNP's refusal to participate in the charter mandated reform process, while BNP warns that the July Charter risks overriding the constitution without due process. Amid this turmoil, the High Court has recently issued a rule nisi questioning the legality of the Charter, the Referendum Ordinance, and the oath taking procedures. The stakes could not be higher. The questions now before the courts touch directly on constitutional supremacy, parliamentary legitimacy, and the future of democratic reforms in Bangladesh. Today, I'm honored to be joined by Senior Advocate Tania Amir, one of the country's foremost constitutional experts, to help us unpack these developments and examine whether the July Charter can legally override the constitution or whether the crisis reveals the dangers of reform without constitutional foundations. So, welcome, Barrister Tania Amir.
Thank you, Tapush. It's an honor and pleasure to participate in this program with you.
So, Jamaat Islami MPs reportedly took two votes, one under the constitution and another under the July Charter. Legally speaking, what is the consequence of taking an oath under an instrument alleged to be unconstitutional? And what would be the position of these MPs since they have taken two oaths, one after the another? Please.
Thank you, Tapush. The post that is recognized by the Constitution is a post of a Member of Parliament. And Member of Parliament's the oath that is designated is also recognized, the words of it, under the Constitution. What is the oath for an MP? They take an oath to uphold, defend, and protect the Constitution. Now, the second oath, which you're talking about, is an oath which is not recognized under the Constitution. The wordings of it is nowhere to be found, but primarily the oath they took is to dismantle the Constitution. So it therefore begs the question that once the Jamaat and the NCP took the second oath, they have violated this solemn oath to uphold, defend, and protect the Constitution. And the next question is, what is the consequence of that? Once your oath of office as an MP is violated, then you're no longer an MP. Consequently, those seats have fallen vacant. I'm going to try and simplify this a little more for our viewers who may not be lawyers. Now, the July Charter, this is something that the Yunus regime perpetrated and prolonged this interim government beyond any reasonable period on the ground that they're going to reform the constitution. Now, the constitution, as you know, Taposh, and your viewers will also know, can only be reformed by parliament. No government has been given any mandate or power to touch the constitution or to reform it. And Yunus created a committee headed by Ali Riaz, who is not a constitutional expert, whose citizenship, he holds the citizenship of US, which also makes him disqualified to touch upon the constitution of Bangladesh. Now, they came up with this July Charter, allegedly by consultation with the Jamaat Islam and BNP. And NCP did not sign this July Charter, and they were not even a political party then. They only signed a few days ago. Now, what they're purporting to do is change the character of the Republic of Bangladesh. They have taken the word democracy out of the constitution, secular, the word secular out of the constitution, and trying to amend the constitution in a manner which is beyond recognition, moving more and more towards this, a theocracy and dismantling the democratic and republican character of the constitution. Now, in order to give effect to this, they came up with a scheme which is absolutely has no basis in law or the constitution. And the scheme is that they're going to go for a referendum and the people will therefore endorse that. And then there will be a constitutional reform committee. And out of that constitutional reform committee, those who are elected, their duty will be to amend the constitution in line with the July Charter. Now, the problem is, referendum is not part of our constitution. It was taken out because once we had constitutional deviation, we had martial law. The martial law administrator initiated a referendum. So when this martial law order was struck down by the Supreme Court, all the orders were struck down. Consequently, the order to hold a referendum, which the martial law administrator purported to insert into the constitution, is also gone. So, in order to have a referendum at all in Bangladesh, first, by two-thirds majority, Parliament will have to introduce this provision of the referendum. And then a second step would be to have an ordinance when Parliament is not sitting to go ahead with the referendum. The second problem is the Election Commission is empowered to hold only two types of election. One is the presidential election, and the second is parliamentary election. An election or a referendum is not something the Election Commission is empowered to perform. No power has been given to the Election Commission, no substantive power to hold a referendum. Only the Yunus government, through this ordinance, referendum ordinance, gave the Election Commission procedural power to tabulate the results forwarded by the center, each center, and then to tabulate and just merely declare what the result is. So the Election Commission has no substantive power. Third is that the government, Yunus government itself, got involved in the referendum. So although no power was given to the Election Commission, the government itself got involved, which no government can ever get involved in a referendum. So Yunus utilized the entire bureaucracy, the police, instructions was given to them. Even the governor of Bangladesh Bank was made to issue orders to all bank officials so they will persuade their clients to give a yes vote in the referendum. And fourthly, the referendum ballot paper had a tick mark next to the yes vote and a cross mark next to the no vote. Any ballot paper which may directly or indirectly influence the voter is rendered null and void. So with those background, this referendum was held. Now, what is even more interesting is that the referendum proposes, the July Charter Ordinance proposes that once the members of parliament are elected, they will form a parallel parliament, which is to be called the July Charter Implementation Committee. Now, no such committee is recognized under the law or the constitution. What is bizarre is that Parliament cannot possibly create a parallel parliament whereby the MPs will wear two different hats. One is that of members of parliament, and which is the oath all MPs took. And the second oath for this parallel parliament to be called the July Implementation Committee or Commission. who will implement this July Charter to take away words, the democratic character, the republican character of the Constitution. What is even more bizarre, in order to amend the Constitution, two-thirds majority is needed by members of Parliament. This July Charter Implementation Commission, the quorum is only 3-0. Out of 300 MPs, only 30 can amend the Constitution. And if they do not amend as per the July Charter, this ordinance purports to say that after 270 days, it will automatically become part of the Constitution, which is rather absurd. It has no legal or constitutional basis whatsoever. So now BNP, once they were elected, they said, well, look, we are members of Parliament and Constitution has already given powers. BNP has more than 200 seats out of 300 seats in Parliament. And with that two-thirds majority, as members of Parliament, should they choose as per their manifesto, based on which they sought votes, and some of the manifesto, some of the issues there is to be able to amend the Constitution. They said, we already have two-thirds majority and we can amend the Constitutions and MPs. So why do we have to take another oath as Constitutional Reform Commission? It's not necessary. And the Constitutional Reform Commission purports to dismantle the Constitution in its present form and character, which is republican character, a democratic character, a secular character, equality of all citizens irrespective of their religious persuasion, their gender, or their color. Now, those are the issues that this July Charter they want to take away. And so, rightly, BNP has said that why should we have a parallel parliament to bring that in? So, BNP refused to take this oath. And as Tapush, you know very well, and I'm sure your viewers also know, that parliament is an expression of the sovereign power of the people. No parliament can be bound, no future parliament can be bound as to what they should or should not do. So here, by way of this devious device that Yunus government along with Ali Riaz have come up with, is to put a shackle upon the future parliament, saying that the future parliament will have a parallel body known as the July Charter Commission, and they shall have to implement this basic structure of the Constitution which they want to erode and dismantle. So this also goes against the very essence of parliamentary democracy. So BNP, of course, therefore refused to take this second oath. Now, because Jamaat and the NCP, which is known as the King's Party, which Yunus created, so he was riding on the back of both the radical Jamaat Islam as well as this King's Party, the Zenzi, mostly it is by Zenzi, but most of the women and girls who are in that party, they resigned because they realized that this is not really this NCP wants to bring about proper changes and a qualitative change in the polity of Bangladesh. Rather, they are radicals and they are anti-women and they are misogynist. So, en masse, all the women and girls who are part of this NCP, they resigned and they openly confessed that they were misled by this radical extremist group, and that NCP is part and parcel of Jamaat Islam and Shibir mostly. And they were responsible for the mobocracy, the mob violence, which was something that the Yunus government gave impunity to these groups to create mobs, to compel the judges of the appellate division, force them to resign, the professors, university professors, whoever was secular and progressive, they were all asked to resign, attacked the leaders of Army League, and their homes were ransacked. And museums, establishments which represented anything to do with our freedom struggle, which brought about the birth of Bangladesh, This is something they want to undo. So this July Charter, they want to give it a place to undo the premise upon which Bangladesh was born, which is a secular democracy. So they dismantled the museum at Road 32, various statues, they ransacked museums, Muktijuddha museums, they ransacked and destroyed the archives, which is irreplaceable, along with the genocide upon Hindus and minorities that was going on. The Sufi, the shrines, about 200 Sufi shrines were destroyed. Women's football was banned. Along with them, there was a cultural genocide. So the radicalization, they wanted to Talibanize Bangladesh, and even the Yunus regime passed a legislation saying that in schools and colleges, no music teacher or physical education teacher would be appointed, and they would be replaced by clergies. They stopped any form of musical exercises, theaters. There were fatwas given against women who are entrepreneurs, the rural women going to bazaars and selling their produce. The bazaars were told women cannot come out. So it was absolutely mayhem that was created prior to the election. And that is what is reflected in the July Charter. So they want to dismantle and take away the syncretic cultural premise upon which Bangladesh was born, which is based on the Bengali nationalism. That's another element of the characteristics of the constitution which they want to take away.
So I will interfere here for our viewers to summarize what you have said till now. For example, first of all, you said that if there is a scenario of constitution versus charter, there is no way that charter has any hierarchy, any even any doctrinal stance in parallel with constitution, because in Bangladesh we have this written constitution according to which any sort of amendment to the constitution has to be made by parliament. Another one is, as I said, that the July charter is ultra vires and the constitution has no provision for such a charter or its referendum. Similarly, the referendum issue is a botched up idea to fraud with the citizens of Bangladesh. That's what you said. And you have also said that what is ensuing after this, which is the cultural genocide, we see that kind of changes they have done. Now, this in this situation, I would like to add that one of the student advisors, have formed a new political party today called Alternatives. And if you note that they have not said anything about constitutional supremacy, about 1971, about secularism, about restoring democracy in the country. They again wants to sell the July, the July and July, nothing else is there. Just for our viewers, now we will get back to this discussion, is that we know that a writ petition or a judicial review process has been filed before the High Court Division of Bangladesh, and Rule Nisi is passed by the High Court Division, asking the government why the July Charter is not illegal, why these oath taking on the basis of July Charter is not illegal, and why this referendum is not illegal. You have already told us that why these things are illegal and not maintainable. But now, what is the consequence that we can expect out of this writ? If you kindly tell us that.
Right. So the cases that are pending, Rule Nisa have been issued. I think there are two cases, and possibly four Rule
Mhm.
Nisa has been issued. Yeah.
Right. Yes.
So the judiciary, as an organ of the government, will definitely strike down anything which is repugnant to the basic structure of the Constitution. So it's a sub judice matter. Let the judiciary do its own job. And I've already expressed my view that since it has no basis whatsoever, both the referendum and this July Charter under the law and the Constitution, most likely I'd be very surprised if the finding of the judiciary was that both of these are ultra vires to the Constitution. Now, Tapush, that is one organ of the republic, which is the judiciary. But we have the parliament, which is the legislative organ of the republic, and we have the executive organ of the republic. I'm going to suggest that all the three organs will have to perform their task. So, judiciary's task is already underway. Now, apart from the judiciary, Parliament is about to sit on the 12th of March. Now, all the ordinances, one of the point perhaps we missed out is that the ordinance that can be passed by a government only when Parliament is not sitting, a ordinance is passed, and ordinance can only be in respect of subject matters upon which Parliament could have legislated. Now, both these ordinances are such.
Also, there has to be an urgency to pass the ordinance.
Yes. Yes. So whether there's an urgency or not, that's a subjective issue, and the government, the UNIS government may argue one with the other. But what is two issues which is most important, that as the ordinance can only be passed in subject matters in which Parliament could have legislated. Now, to hold a referendum, no Parliament could have legislated on that without first amending the constitution with two-third majority. And so this is two steps. One is that Parliament will have to introduce this whole concept of a referendum by amending the constitution and inserting this in the constitution by two-third majority. Only then there could be a legislation, an act of Parliament, which would allow for such a referendum at a given point in time. So there are two steps. What UNIS government has done is that they have passed an ordinance. That ordinance has no basis whatsoever because no parliament could have directly passed a law, a statute to hold a referendum without first amending the constitution. So therefore, this ordinance has no life force. It's a stillborn birth. It's void from day one. Now, the other feature of an ordinance will only be passed when Parliament is not sitting. So, all ordinances passed by UNIS regime these ordinances shall have to be laid before Parliament within 30 days of Parliament sitting. Now, if Parliament does not ratify these ordinances because they're stillborn, it has no life force. So Parliament cannot inject life into this ordinance, which is a stillborn birth. Parliament cannot possibly allow and legislate to create another parallel parliament, which is this Constitutional Reform Commission, right? With only a quorum of 30
MPs.
members. Yes, not MPs, just members.
Okay.
Because
Right.
MP is separate. The MPs wear a separate hat. These are members of this commission,
Of this commission or committee, whatever.
Constitutional Reform Commission. Yeah. Parliament, it's unheard of, it's unthinkable that Parliament will ratify these, which is stillborn, and Parliament cannot possibly breathe life into these ordinances, which was stillborn. So therefore, if Parliament does nothing, these ordinances are buried. These are dead, has no life force, it will be buried. Second thing Parliament can do is debate it, but Parliament may not even dignify it by introducing a bill and a motion to even debate it. So Parliament may not even dignify these nonsense, waste of time, piece of paper, which is worse than a toilet paper. It has no purpose, no
But
function.
can BNP alone do that? Because a bill can be floored by the opposition as well.
Yes, it can. BNP now has 209, 212 seats
Mm-hmm.
after by-election.
Yeah.
So they have simple majority would suffice not to ratify it.
True.
But they have They have, so it'll be futile exercises.
But
Now,
do you, don't you think? Yeah.
if I may, if the opposition Jamaat or members of the NCP proposes a new bill, now this would come up as an independent bill, not as a July charter, if you like.
Right.
So they are therefore accepting that there's no such thing as a constitutional reform commission, you see.
Hmm.
So because they're wearing two hats. They're wearing the hat of members of the Constitutional Reform Commission, which is non-est, which doesn't exist in the eye of law. And the other hat they may be wearing is that of an MP in the opposition. So as an opposition MP, if they're introducing a private member's bill, then they themselves have buried this ordinance. So they are therefore admitting that there is no scope of the function of this Constitutional Reform Commission or a parallel parliament. So they are floating this bill as a private member's bill as individual MP. Okay, so then they're falling within the four corners squarely within the framework of parliamentary democracy. And that bill is a fresh bill. It has nothing to do with implementing the so-called July Charter. So, and that BNP can defeat, I mean, it'd be futile exercise anyway. But if they were to do so, it would be an admission that there is no such thing as a constitutional reform commission. It doesn't exist. So that will also be would be a good thing if they were to do that.
But
Yeah.
what I wanted to say, according to your argument, or the argument that we are talking about, that they are not member of parliaments anymore, right?
Yes.
So, so do you think that even to debate over these bills, there has to be a fresh election on these seats? Do you suggest that?
It's a process. So
Hmm.
first, I think that these so-called ordinances, which is stillborn, let it be buried in Parliament. So whether these 78 seats consisting of the radicals and radical 2, which is
New radicals.
NCP,
Yeah.
yeah, the new radicals, and not a single woman have been nominated by them. So they're all, radical males who are also involved in violence and mob culture. Their presence is not significant because they only have 77 or 78 seats in parliament. Once these so-called ordinances, which is stillborn, is buried, well and good. And mind you, the other organ of the republic, which is the judiciary, has already challenged. This is under challenge. So the judiciary is most likely to render this as void ab initio and ultra-vires to the constitution. The word usually used by parliament is repeal, right? So
Hmm.
I hope Parliament would consider using the word void ab initio because from a jurisprudential point of view, this is important. But even if all these ordinances are laid before Parliament and Parliament doesn't do anything, then something that is already dead will be buried, but the word will be repealed. So therefore, to that extent, I think it's important that the judiciary has issued the rule because something which is stillborn cannot be repealed. A repeal is something that had life force, something which is born alive, you can repeal it. Yeah. But something which is dead, you can't, the question of repealing doesn't arise. It's void, it's null and void. Okay. So let Parliament as a functionary of the Republic, as a organ of the Republic, the functionaries of Parliament, namely the MPs, let them play their role. Now, after that, the election commission, I think election commission who administered this oath will need to be asked, where did he find this oath? Who wrote it? Who gave it to him? Because there is no such oath for the Constitutional Reform Commission. So now I'm moving to the executive organ of the government, of the Republic. right? So
Mhm.
we talked about the judiciary, which issued the rule. We talked about the parliament, what parliament should do. I believe that there's a duty upon the executive organ of the republic as well. So the government should create an inquiry commission. We should bring out a white paper as to under whose instruction this so-called July Charter, because BNP already took the stance that there's a serious fraud because the issues in this July Charter, which BNP does not agree to, or they have given their dissent and their reservation, was not reflected. So there was a fraud upon BNP as well. So this white paper should bring about that how the election commission conducted this referendum, because the election commission actually issued a show cause notice, if you remember, Tapush, to the government, saying that the government is getting involved directly in the referendum. What is the interest of the government? And this is absolutely illegal. So that letter is a very important evidence. So that should be used in this inquiry, a government inquiry. And who wrote this second oath? And based on this second oath, this parallel parliament known as the Constitutional Reform Commission with a quorum of only 30. And if they didn't do the work, how is it automatically becomes part of the Constitution? So this is a harebrained, a devious mechanism, a device, very ill thought through, which has no basis in law of the Constitution. Only
Actually,
non-loyalists
the,
can
the,
come
the
up with
scheme,
so silly.
sorry, the scheme that you mentioned in the very beginning of our discussion was actually made keeping in mind that Jamaat is coming to the power. They actually didn't think about any other alternative. So that is what is my perception is. Now I will ask you
You
two
could
last.
well be right, Tapush, because
Mhm.
we also saw the night before the election, all the centers, many of the centers were occupied by Jamaat and
Right.
NCP people, and they were stuffing the ballot boxes and so on. So, yes, this was probably part of the scheme. And some people say the scheme was that if Jamaat and the radicals with the mob, the NCP mob, if they came to power, the Jamaat doesn't have a face of acceptability. So they wanted Dr. Yunus to become the president to
Mhm.
make it more palatable to the Western world that Yunus would be the president. And this is very interesting because in the July Charter, the power dynamics between the president and the prime minister was also purported to be altered. So more and more power was given to the president, and the less and less power was given to the prime minister. And even appointing of various offices like the energy, oil and
Commission.
gas,
Yeah.
the Energy Regulatory Commission, the governor of Bangladesh Bank. So the various trade deals that is to be given to the Western powers, for oil and gas, the Energy Regulatory Commission, the governor of Bangladesh Bank, because we know that 3 days before the election, the government signed a secret trade agreement
Exactly.
with
Yes.
USA. Now, this is a public procurement, a public deal with public money. Now,
Mhm.
the whole concept of a non-disclosure agreement, an NDA, it doesn't exist in the public domain. The NDA only exists in the private sector. If two private sector companies are entering into an agreement, and if there are trade secrets, if
Mhm.
there's a patent, there's a copyright, only then, the formula of, say, the beverage, like
Of
Coca-Cola,
Coca-Cola,
for
yeah.
example. Yes. So if there is some form of a secret formula, trademark, a copyright, or some sort of a IT related formulation, only then there's a non-disclosure agreement. But in the private sector, where the people, the public is paying for these, how can there be a non-disclosure agreement? So that agreement, I am convinced, will also be challenged before the court and also be rendered a void ab initio. because Bangladesh signed many agreements with foreign countries. Now, they may be unfair, they may be one-sided, but Bangladesh has a very good track record from Standard & Poor and Moody, who rate the countries, because we never, if you like, rendered those agreements null and void. We never canceled them, nor have we nationalized or appropriated assets. But this agreement, I would suggest, is very different, because those agreements were not secret documents. The government is authorized, and they sign any agreement with a foreign party or a foreign country for and on behalf of the people. As
Absolutely.
Dr. Lewis forgot that.
Yeah.
So if the
So
people don't know about it, then there is no validity of that agreement. And I think this can also be challenged before the US court, because the US, which propagates democracy and rule of law, how on earth has US entered into an agreement with Bangladesh to promote the interest of US, and Bangladesh as a vassal state is somehow subservient to serve the interest of US and not the interest of the people, and the people will pay for it?
mhm.
That's absurd. Free market, free trade, Bangladesh will procure the goods where they get the best deal.
True. I will interrupt here because since we are not talking about this agreement, but thank you very much, because this is also illegal, and this also shows that how malafide intention Yunus government had. They
Yes.
wanted to get themselves benefited out of this whole deal. They
Or
didn't
be in the
think
good
about.
books of the superpowers so they can perpetuate
Absolutely.
themselves
Absolutely.
indefinitely.
So I will just ask you the last two questions. The first one is that as soon as is BNP declaring July Charter being unconstitutional, and since writ petitions are filed before the High Court division, we are seeing that NCP and the Jamaat is again threatening that they will take this whole deal on the streets, and again they will blackmail the general people. And what do you think about it? That should BNP allow this to happen? Something like July August drama is going to be enacted again, it seems. So, what is your suggestion? What should the BNP do to avoid this situation?
Yes, I'm in no position to advise BNP. I'm not their advisor. They've not sought my advice. But let me look at it from a constitutional perspective. Now, we have an elected government. Now, the election was not inclusive, so it's faulty. But by no means can we say that the election is illegal or unconstitutional, because any interim government, whether it was Yunus regime or any regime in the world, the only mandate they have is to hold an election and disappear as soon as possible. So we cannot say that the Yunus government, their legitimacy is in question, but an interim government cannot hold election. It's not a view that I would take or propose. So I'm making a total distinction between the election and a referendum. Referendum, Yunus government had no mandate to do whatsoever, because referendum is not recognized under the constitution. But election is a due process and duly recognized under the constitution, and that is the only way you get rid of the Yunus regime, by way of election. Now that we are on the gotten ourselves on the track of an elected government, albeit, as I said, the election is faulty, but it's not illegal. All right, it's not ultra virus, whereas the referendum is absolutely ultra virus to the constitution. Now, if members of parliament who claim themselves to be members of parliament, if they're doing street agitations as opposed to debate in parliament, this constitutes, if you like, terrorism. This constitutes holding the people a ransom. This is violence, which is unjustified, right? So there, the difference, I believe, that NCP was states sponsored by the Yunus government. They gave them impunity to do this mob, but this mobocracy, the mob that they will hold, are absolutely criminal acts. Arson, creating a mayhem in the streets, stopping people from going about doing their own business, going to the office, attacking political opposition. Now there's a parliament go and do it there. So that is one thing. I think the government, and I'd like to give benefit of doubt to the BNP government, and would like to believe that we had such a close shave with anarchy and anti-democratic regime that BNP will ensure to the best of their ability rule of law. And whoever takes law into their own hands and creates arson, which kills innocent people, attack upon minorities, upon the Sufis, secular people who do not believe in this dogma that they're propagating, the government will take proper action. But I want to add, if I may, Taposh, on this. So once a new election commission is appointed, which I believe is due, because the election commission who administered this second oath, I think I was telling you that there are three organs of the republic,
Mhm.
and each organ has their own respective duties
Right.
to look into and undo this July Charter and the referendum. So the government should do a white paper, look into the election commission. And since the election commission, along with those who took the second oath, would be under the scrutiny and investigation, then obviously there will need to be a new election commission. And once the new election commission will be in office, shall have to, under the constitution, of course, issue a show cause notice upon these 78 members as to why their office will not be deemed to have fallen vacant,
Mhm.
because their second oath that they have taken to dismantle the constitution, it clearly violates the first oath. Now, I'm going to make a very subtle distinction here, Tab.
Mhm.
I'm not suggesting for a moment that the second oath is valid, therefore it has nullified the first oath. No, the second oath has no premise in the eye of law whatsoever. But they have undergone a ceremony, a ritual, which violates the solemn content and substance of an oath of a member of parliament, and they didn't even wait 24 hours. They didn't wait 12 hours. They didn't even wait 2 hours. Immediately after the solemn oath to uphold, defend, and protect the Constitution, they have undergone a ritual, because this second oath cannot be deemed as an oath because that body doesn't exist in the eye of law. They have undergone a ritual which, by that very act, violates the oath of an MP. And hence, they have become a void ab initio.
Right.
Now, the analogy I may draw that, in UK, for example, you're in Germany, bigamy is an offense, undergoing the ceremony of a second marriage. Now, the ceremony of the second marriage is not considered a marriage. Yeah. So undergoing the ceremony, the ritual of this so-called marriage ceremony is itself an offense, which which renders the person undergoing that ceremony liable to criminal offense. So now, similarly, the second oath, as we have been saying, to make it easy for our viewers to understand, it's not an oath. It is no oath in the eye of law. There's no office known as the member
As
of
you said,
constitutional.
it's a void ab initio.
It's void ab initio. But what they have undergone is they have undergone a ceremony, a ritual, which violates the first, uphold, defend, and protect the Constitution as a member of Parliament. So, just as the second ceremony of marriage, which is not a marriage, it's not accepted a marriage in the eye of law, it's merely a ritual, it's merely a ceremony. Similarly, the second oath, which is merely a ceremony, a ritual, a ritualistic exercise that they've gone through, has absolutely, totally undermined and violated the oath of office of a member of parliament. Hence, they're disqualified. Hence, they've lost those seats. So the show cause notice should be therefore given by the election commission. And after a reasonable period of time, that will be mentioned in the show cause notice as to why these offices shall not be deemed to have fallen vacant. and then hold a by-election. And I would say that as per the, in order to ensure rule of law, all parties should participate. This by-election should be inclusive. Now, I cannot blame BNP for this election, which is faulty, because this election was organized by the Yunus regime, and Yunus regime is critiqued as being a regime that held a faulty election, which is not inclusive. BNP can easily remedy that. BNP can lift the ban that has been imposed upon Awami League and hold an election which will be inclusive. And in this election, I would hazard a guess that out of the 78 seats, I think this will be distributed amongst and between majority of them between Awami League and BNP. So, which will reflect the actual position of Jamaat Islam and NCP in the country. Because as you mentioned, a lot of these seats, a lot of these centers in the middle of the night before, BNP and Jamaat and NCP occupied, and they were stuffing ballot boxes and so on. And in those seats, mostly in the border area and in Dhaka, they're a stronghold of Awami League. So it is more likely than not that out of the 78 seats, if not almost all, majority will be won by Awami League and BNP. So we will see NCP and Jamaat more or less obliterated politically from the political landscape of Bangladesh, which would really reflect the true character and nature of the syncretic Bengali majority, Bengali people in this Bengali nation, which was founded on the premise of language and culture, not on the basis of religion. Now, when Bangladesh broke away from Pakistan, it proved beyond all reasonable doubt that nationalism cannot be based on religion, and religion cannot be a glue that held the two wings of Pakistan together. If that be the case, then Europe, which is majority Christian, would be just one country. How come Germans have their own country and the language they speak is Germany? France, they speak French and they have a separate country. The English, Great Britain, they speak English. Italian, the same thing. So modern day statehood is really predicated upon the language and culture of the people. Even if we look at ancient India or even the different states in India, in the south, the Tamil Nadu, they speak their own language. In Bengal, they speak Bengali. In Punjab, they speak Punjabi. So all the different states, they have their own language and their own culture. That is the basis upon which nationalism, the modern day nationhood, is founded. And Bangladesh, our birth, shows that an Islamic republic is an oxymoron. Religion cannot be a glue that holds people together. Bengalis, the Bangladeshis, it consists of, albeit majority Muslims, but the identity is not professed on the basis of religion. So religion is a personal affair, and the statecraft is for all citizens. So when we had the language movement, 1952, which gave rise to this Bengali nationalism, we called ourselves Bengali. That is the identity in which we professed ourselves. So if you lift the veil of Bengali, there could be Hindus, Buddhists, Christians, Muslims, non believers, atheists, anybody. But the cultural identity, the syncretic identity, was Bengali nationalism. And the language movement today, the world has recognized
Now, what I understand is
as the Mother Language Day.
right. What I understand is that Bengali culture is a diversified culture. It doesn't only mean Bangla language, right? Because we have ethnic minorities. We have Chakmas, we have Marmas, Morongs, and we have total respect and for their language and culture, and they can perform those things openly and freely. That was made possible because Bengali nationalism was there, right? So I will. Uh, I mean, we have reached to the end.
Yeah,
So,
you raise a very interesting point. Let
right,
me just address it very quickly, although we could have a whole program based on that.
right,
Bengali nationalism is an inverse nationalism. So basically, the Puritan Muslims who call themselves West Pakistanis wanted to impose a puritanical, insular, very narrow band of Islam, and where the definition of Islam would not include Ahmadiyas or Sufis or even Shias to a degree. So it was very, very puritanical. And they wanted to impose this narrow, insular Islam upon the people of Bangladesh. Now, we revolted against that. And we said, no, we're Bengalis, and this is very inclusive. So, the Bengali culture, we have 6 seasons. So we have festivities of the spring, Bashant Utsav, we have winter festivities, the winter Pitha Utsav, we have the Pohela Boishak in the summer. And just as we embrace different season, we embrace different people of different color, caste, their linguistic variation. So the Bengali nationalism is very, very inclusive, and we are embracing. And
exactly,
Bengalis are known for their hospitality and how to embrace people of different origins. So where the chauvinism of the Urdu and the Islam, the radical chauvinistic Islam that was purported to be shoved down our throat, we rejected it. We said, no way. This is a beautiful syncretic culture from time immemorial, people who have lived in this land. And Bengal is very well known for its tapestry, the Nokshikatha, which is a tapestry of different colors, different landscape. So the civilization, which is very ancient, Bangladesh may be relatively new, but Bengal is an ancient civilization. It's a tapestry where people from different ethnic groups have come and joined, and it is blended. It's a blending is similar to the Nokshikatha of Bengal, with our music, with our culture, and our celebration of different seasons, different colors. And we are not narrow minded people at all.
right,
So we reject chauvinism of all forms, whether
exactly.
it's based on gender or religion.
Thank you. On the eve of that historical speech by Bangabandhu, father of the nation, Sheikh Mujibur Rahman, this episode will come out. That's how our audience will understand the concluding statements you made, that why Bengali nationalism is inclusive and it is diverse. So, with this note, we will conclude today. Listeners, you have been listening to the SADF podcast. My thanks to Senior Advocate Tania Amir for offering her analysis at this pivotal moment in Bangladesh's constitutional journey. As we have heard today, the July Charter has not only triggered a judicial review at the High Court, but also deepened political divisions, particularly between BNP and Jamaat Islami, who now find themselves on the opposite sides of the issue. Whether it's BNP's insistence on adhering solely to the constitutional oath or Jamaat's push to validate the charter through dual alliance, the political landscape is shifting rapidly and contentiously. With the legality of the charter, the referendum, and the oath taking process under judicial scrutiny, the coming weeks could reshape the constitutional order in Bangladesh. Will Parliament proceed as a constituent assembly? Will fresh elections be required in constituencies where dual oaths were taken? And can political consensus ever be reached in this polarized climate? We will continue to follow these developments closely. Thank you for joining us. If you found this discussion insightful, please subscribe and share the podcast. Until next time, I'm Tapas Kanti Baul. Stay informed, stay engaged, and stay safe. Thank you.
Thank you, Tapush. Joy Bangla.
Jai
Thank
Baba.
you.